Welcome to our deep dive into geographical indications and intellectual property law. In this video, we'll explore how geographical indications protect unique products, their cultural significance, and the legal frameworks that support them. We'll also cover major international treaties like the Paris Convention and the Madrid System, which shape global IP protection. Whether you're a student, artisan, or business owner, understanding these concepts is crucial for safeguarding creativity and tradition. Let's begin by unraveling the basics of geographical indications and their role in the world of intellectual property. Geographical indications, or GIs, are signs used on products that have a specific geographical origin and possess qualities, reputation, or characteristics inherent to that location. Think of Darjeeling tea or Mysore silk. These products are renowned not just for their quality but for their connection to a particular region. GIs help consumers identify authentic goods and support local economies by rewarding tradition and craftsmanship. They are more than just labels, they are a bridge between culture, environment, and commerce. Nature of geographical indications is rooted in their ability to identify goods as originating from a specific country, region, or locality. This includes both geographical names and traditional names with acquired significance. For example, champagne from France and basmati rice from India and Pakistan are recognized globally for their unique qualities. GIs form a vital part of a country's culture and traditions, preserving heritage and ensuring that only genuine products receive recognition. Geographical indications serve several important functions. They identify the source and quality of a product, assure consumers of standards, protect the livelihood of artisans and craftsmen, generate employment, and retain populations in specific regions. GIs also provide valuable information about product attributes linked to geography, helping consumers make informed choices. By establishing a clear link between products and their origin, GIs foster loyalty and preserve cultural practices. Protecting geographical indications is essential for several reasons. GIs inform customers about product quality and reputation, safeguard trade interests, and protect the livelihoods of artisans and craftsmen. They also assure consumers of unique standards, qualify for protection under international agreements like TRIPS, and secure customer loyalty. Additionally, GIs offer cultural protection, ensuring that traditional knowledge and practices are passed down through generations. Geographical indications reward tradition and emphasize the relationship between cultures, environment, land, and resources. They are not transferable, protecting collective heritage and ensuring that knowledge is passed down through generations. GIs also promote collective tradition and protect the interests of producers, making them a powerful tool for preserving cultural identity and supporting sustainable development. Geographical Indications of Goods Registration and Protection Act, 1999, aims to protect the interests of producers, exclude unauthorized persons from misusing GIs, and promote goods-bearing GI in export markets. The Act defines GIs, extends protection to agricultural, natural, manufactured goods, and handicrafts, and ensures that only genuine products receive recognition. By setting clear standards and procedures, the Act strengthens the legal framework for GI protection in India. Appellations of origin refer to products whose quality and characteristics are exclusively or essentially due to their geographical environment. Examples include Bordeaux wine from France, Jamaican Blue Mountain coffee, and tequila from Mexico. These appellations highlight the unique link between product attributes and their place of origin, reinforcing the importance of protecting such names to preserve authenticity and reputation. Indication of source simply refers to the country of origin of a product, without necessarily implying any special qualities or characteristics. While it doesn't carry the same weight as a GI or appellation of origin, it still plays a role in informing consumers about where a product comes from. This distinction is important in understanding the broader landscape of product labeling and protection. Applying a geographical indication involves several steps. A GI can be applied directly to goods, their packaging, or used in advertisements, invoices, catalogs, and other commercial documents. The law ensures that any use of a GI is reasonably likely to lead consumers to believe the goods are designated by that GI. This comprehensive approach prevents misuse and ensures that only authentic products benefit from GI protection. Falsifying a GI means creating or altering a GI without the assent of the authorized user, while falsely applying a GI involves using a GI or deceptively similar GI on goods or packaging without permission. These actions undermine the integrity of GIs and can mislead consumers. The law provides strict penalties for such offenses, ensuring that only genuine products are associated with recognized GIs. Registration process for geographical indications is detailed and rigorous. Applications must be made to the registrar of GI by associations, producers, or organizations representing the interests of producers. Essential requirements include facts about the goods, attributes linked to the territory, human skill involved, uniqueness, and inspection methods. The process ensures that only genuine and distinctive products are granted GI status, protecting both producers and consumers. GI application must include a brief explaining the nature of goods, attributes linked to the originating territory, human skill involved, uniqueness, and inspection particulars. It should also mention the class of goods, geographical map, appearance of the GI, and details of producers. The application must be clear, comprehensive, and supported by evidence to ensure proper protection and relief in case of infringement. Sometimes, a single GI application may cover multiple classes of goods. In such cases, divisional applications can be made, dividing the original application into separate ones for each class. This process ensures clarity and proper classification, allowing for more precise protection and easier management of GIs across different product categories. Once a GI application is accepted, it must be advertised in the Journal of Geographical Indication within 3 months. This publication is also made available on the registry's website or suitable electronic media. The advertisement process ensures transparency, allowing public scrutiny and objections before final registration. Certain geographical indications are prohibited from registration. These include GIs likely to cause deception or confusion, those contrary to law, scandalous or obscene matter, or those likely to hurt religious sentiments. Generic names, indications protected in another country, or those falsely representing origin are also barred. This ensures that only genuine and appropriate GIs are protected. GI Act confers exclusive rights to the proprietor and authorized user to use the GI in relation to registered goods. It also provides the right to obtain relief in case of infringement. However, these rights are not absolute and may be subject to conditions or limitations, such as variation in labeling, area of operation, or blank space requirements. The Act ensures balanced protection for both producers and consumers. When 2 or more authorized users are registered for identical or nearly resembling GIs, their rights are co-equal, meaning exclusivity does not operate against each other. In case of death, the right in a registered indication devolves on the successor in title, ensuring continuity and protection for genuine producers. Geographical indications and trademarks are often confused, but they differ significantly. Trademarks distinguish goods and services of one producer from others, while GIs show similarities of a group of products based on their source. Trademarks are private monopoly rights, created by inventive words or symbols, whereas GIs are collective public rights rooted in tradition and recognition. GIs cannot be assigned, and their protection is linked to public perception and cultural heritage. Trademarks can be letters, words, numerals, abbreviations, devices, sounds, or smells. They are proprietary with exclusive rights for the owner. In contrast, GIs are linked to geographical names and symbols, and their rights are shared among all producers in the region. Trademarks can claim color features, while GIs cannot. This distinction is crucial for understanding how products are identified and protected. Collective trademark belongs to a group or association and is reserved for members. In contrast, a GI identifies goods as originating from a certain region and is not limited to a specific group. All producers in the region can use the GI, making it a common heritage rather than a private right. This distinction helps maintain authenticity and collective recognition. Infringement occurs when a registered GI is used by an unauthorized person, or in a manner that misleads consumers about the origin of goods. Acts of unfair competition, passing off, or using expressions like kind, style, or imitation also constitute infringement. The law provides remedies for infringement, including injunctions, damages, and destruction of infringing labels. Only registered GIs are protected, but passing off actions can be initiated for unregistered GI. Legal remedies for GI infringement include injunctions, damages or account of profits, and delivery up of infringing labels. Injunctions can be temporary, permanent, or ex parte, preventing greater harm to the plaintiff. Damages or account of profits are alternative remedies, and the court may order destruction or erasure of infringing labels. These remedies ensure effective protection for GI holders. Suit for infringement of a registered GI or for passing off must be instituted before the district court having jurisdiction. The term includes courts within the local limits where the plaintiff resides, carries on business, or works for gain. This ensures that GI holders have access to legal remedies and can protect their rights effectively. If the validity of a GI registration is questioned in a suit, the court may stay proceedings pending rectification by the registrar or appellate board. This allows for proper resolution of disputes and ensures that only valid GIs are protected. The stay does not preclude interlocutory orders, such as injunctions or appointment of receivers. The Act protects against groundless threats of legal proceedings for GI infringement. If a person threatens another with action for infringement without justification, the aggrieved person may seek a declaration, injunction, and damages. This provision prevents misuse of legal threats and ensures fair treatment for all parties. Criminal remedies include penalties for falsifying or falsely applying GIs, selling goods with false GIs, falsely representing a GI as registered, and falsification of entries in the register. Punishments range from 6 months to 3 years imprisonment and fines. Enhanced penalties apply for repeat offenses, and the court may order forfeiture or destruction of goods involved in the offense. The GI Act allows appeals to the appellate board for decisions by the registrar. Appeals must be filed within 3 months with possible extension for sufficient cause. The appellate board has exclusive jurisdiction over matters related to GI registration, ensuring specialized and effective resolution of disputes. The registrar has the right to appear and be heard in legal proceedings before the appellate board, especially in cases involving alteration or rectification of the register. The registrar's involvement ensures proper administration and adherence to legal standards in GI matters. Dyer-Meeking Breweries v. Scotch Whisky Association. The Delhi High Court refused to register the mark Highland Chief for whiskey produced in India, as it was likely to deceive consumers into thinking it was Scotch whisky. The court emphasized the importance of protecting geographical indications and preventing false trade descriptions. This case highlights the role of GIs in safeguarding authenticity and consumer trust. Scotch Whisky Association v. Pravara Sahkar Shakar Karkhana Limited. The Bombay High Court restrained the defendants from passing off their Indian whiskey as Scotch whiskey by using misleading labels and descriptions. The court held that even blending a small percentage of Scotch whiskey did not justify marketing the product as blended Scotch whiskey. This case reinforces the strict protection of GIs against misleading practices. Scotch Whisky Association v. Golden Bottling Limited. The Delhi High Court granted a permanent injunction and damages against the defendant for using the word Scot in whiskey labels, misleading consumers into believing it was Scotch whiskey. The court recognized the GI protection under WTO TRIPS and Indian law, awarding damages and costs to the plaintiffs. This case demonstrates the legal remedies available for GI infringement. Darjeeling tea is a registered GI, recognized for its unique taste, aroma, and mouthfeel. Grown in 87 gardens in West Bengal, its distinctive character is attributed to the region's elevation, soil, and climate. The GI ensures that only tea produced in this area can be labeled as Darjeeling tea, protecting both consumers and producers from imitation and misuse. Orissa Patachitra is a GI for traditional wall hangings and paintings made of textile and natural colors. The art form is rooted in ancient traditions, using vegetable and mineral colors, and is inspired by Hindu mythology. The GI protects the authenticity of Orissa Patachitra, ensuring that only genuine artisans receive recognition and preventing fake claims from neighboring regions. Mysore silk is a GI for pure silk products manufactured in Karnataka. Known for its extraordinary quality, luster, and intricate zari work, Mysore silk reflects the region's royal heritage and tradition. The GI ensures that only silk produced in Mysore can be labeled as Mysore silk, protecting the reputation and demand for this legendary fabric. Paris Convention for the Protection of Industrial Property is a foundational treaty for intellectual property rights. It covers patents, trademarks, industrial designs, geographical indications, and unfair competition. The convention guarantees national treatment and priority rights, allowing inventors and businesses to protect their creations internationally. Its provisions are implemented through domestic laws, shaping the global landscape of IP protection. Paris Convention was born out of the need to harmonize patent laws and avoid loss of eligibility for patent protection due to publication or exhibition. It was first signed in 1883 by a handful of countries and has since grown to include 172 members. The convention has undergone several revisions, adapting to changing needs and expanding its scope to cover various aspects of industrial property. Principle of national treatment ensures that each member state grants the same protection to eligible foreigners as it does to its own nationals. This even-handed approach applies to patents, trademarks, and other IP rights, preventing discrimination based on nationality. Exceptions exist for procedural requirements, but the core idea is equal protection for all. Right of priority allows applicants to file a first patent or trademark application in one country and then file subsequent applications in other countries within a defined period, retaining the original filing date. This preserves novelty and prevents loss of rights due to publication or exhibition. The priority right is crucial for inventors and businesses seeking international protection. Paris Convention establishes common rules for patents, including independence of patents, right of the inventor to be named, protection against forfeiture due to importation, and provisions for compulsory licenses. It also guarantees grace periods for maintenance fees and temporary protection for inventions exhibited at international fairs. These rules ensure fair and effective protection for inventors worldwide. Convention provides rules for trademarks, including cancellation for non-use, protection for marks used in different forms, concurrent use, grace periods for renewal, and independence of trademarks. It also protects well-known marks, state emblems, collective marks, industrial designs, and trade names. These provisions create a robust framework for trademark protection across member countries. Paris Convention obligates member countries to repress unfair competition, defined as acts contrary to honest practices in industrial or commercial matters. Examples include creating confusion, false allegations, and misleading indications. These rules protect both competitors and consumers, ensuring fair trade and integrity in the marketplace. Madrid system offers a convenient and cost-effective solution for registering and managing trademarks worldwide. By filing a single application and paying one set of fees, applicants can seek protection in up to 123 countries. The system is governed by the Madrid Agreement and Protocol, administered by WIPO, and provides the legal equivalent of national registration in designated countries. Patent Cooperation Treaty, PCT, simplifies and economizes the process of obtaining patents for inventions internationally. By filing a single application, applicants can seek protection in multiple countries. The PCT regulates formal requirements, provides for international search and preliminary examination, and ensures that national patent offices receive comprehensive information for granting or refusing patents. World Intellectual Property Organization, WIPO, was established to promote the protection of intellectual property worldwide. Its objectives include administrative cooperation among IP unions, setting norms and standards, providing legal technical assistance, and facilitating international registration of patents and trademarks. WIPO's organs, such as the General Assembly, Conference Committee, and Coordination Committee, ensure effective governance and support for global IP protection.